I'm going to call us to order. Start with the pledge, and Sherry Newquist, would you pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, and Sandy, if you could do a roll call. Oh, dear.
Logan.
Here.
Bullock.
Here.
Butler.
Here.
Freeman. Revis. Newquist.
Here.
Trinier.
Present.
We have a quorum.
Wonderful. And first thing up on our agenda is approval of the minutes from October 15th. Oh my gosh, it's been a long time.
Motion Newquist.
Second, Logan.
Okay. Logan.
Yes.
Bullock.
Yes.
Butler.
Yes.
Newquist.
Yes.
Trinier.
Yes.
Motion passes.
All right, I hate to think, I'm gonna not think, right? Because that, oh, come on, agenda, come back. There we go. All right, so we were going to review some chapters today because we do have a new member to our committee. And just briefly, Dawn, I think everybody, or Member Bullock, I think everybody has, and of course, we have Mr. Pelkey here who is new to the program. These ordinances hadn't been reviewed in 20 or 30 years. How long was it?
Last time there was a full.
Oh, yep.
How do I do that?
You push your button and then I'll make you live. There you go.
All right, thank you. The last time the entire Code of Ordinance was done was 1981. We have updated some parts. There's some parts that we updated in 1981. It still uses statutory language from the 40s. It doesn't exist anymore. So we undertook this in order to just basically bring them up to date. All of these items that we're talking about reviewing the old business, we've already in this committee previously talked about. And what I am attempting to do is bring forward all the provisions with any changes in law, removing things that is no longer statutorily available to us. Because sometimes we did stuff and then state took away our power to do it and we can't do it anymore. We also had a lot of language in our Code of Ordinances from back when the county board wore two hats, both county executive and county board hat. So there was a lot of procedural language about what you guys did administratively to run the government. You previously had as you have a chief of staff now to help you with your legislative, you had county board, I forgot his name, but it was administrator who basically did what the county executive does on your behalf. And so that had to be eliminated because that doesn't exist anymore. Since the review we did last fall on these, I also checked January 1st to modify anything to any statutory changes. Because we all know in January and it's like July 1st, they do new state laws come into effect unless they come into effect immediately. So I did track it to make sure that nothing else has been impacted by it. Even in some of our ordinances, after we changed them a little bit after the county executive came into being, then recently the county executive statute was changed. So I had to make sure that those provisions matched the state rules as well. So that's basically where we're at. What I'm going to request of this committee, if you are willing, and what I would like to do is we review these things. Whatever we don't get done, we're going to obviously put forward as old business next month. But what I intend to do to you is next week and every week after we have a meeting, I want to give you another 2 chapters to review. I don't want to give you everything at once, but title 1, and they're called titles, not chapters. And we only go with odd numbers. When they set it up, it's 1, 3, 5, 7, 9 with Roman numerals. And the reason I did that is the American Publishing that did this for us left even number spots if you had to put more stuff in that you could do.
Thank you. That answers Member Bullock's question, I
Yeah,
think.
that's why they did that. They created it that way in order to have room. And they sort of parroted how you did it off of the state statutes. There wasn't every one used. And you'll notice even when I'm going through these, there might be some where we don't use the numbers. They're left blank. And the reason I left them blank is we may get sued over something 10 years from now based on a law that is in effect now. And if our ordinances show that there used to be a certain provision that's empty, that gives them a chance to go back and look at it and say, what did it used to be from a historical perspective? Because you got to look at the legality of when it was passed necessarily, and because that could impact it. So that's, you're going to notice that all the numbers may not necessarily match. One of the things I did try to also add is in parentheses at the end, and you'll see them in red, but eventually when they're typed, they won't be red. I wanted to put the state authority for what we did in case we have to look it up sometime, because we didn't always do that. Sometimes we did, sometimes we didn't, but I'm trying to get a little uniformity in our pattern. I also am trying to go with some uniformity under numbers, capital, vowels, Roman numerals, lowercase, letters, that kind of thing. And I miss it sometimes, but I'm trying to keep up with it. And my intent is when I get this to you earlier, I'm going to send, in order not to violate Open Meetings Act, I'm going to send it all to you one by one. The Chuck, Sandy, Mike Mahoney for the county executive will get CC'd when I send the first one to Jackie. But the same day, I'll send all of you one individually, and I'm going to have a message on there. Since I'm only part-time, here is my work direct line. Here's my home number. Here's my cell number. If you have any questions and want to discuss it before the meetings, call me and I'll give you some historical background or explain it. And that doesn't mean you have to take my explanation. That doesn't mean you have to agree with me, but I want to give you the background because that'll save some time. As your vice chair knows, Vince, when he was chair last time, a lot of the meetings were spent with people asking individual questions about individual items, and they may be the only person interested in that. I'm trying to avoid that. So when we get to the meetings, we're like 95%, maybe 90% in agreement with what we need to do. And we just say, all right, everybody ready to approve Title I? Are you? And if there are any questions, then if one person has a question, we do it. Otherwise, we can just approve it. I'd like to get a lot of the work done outside of the committee if possible, just to get everybody on the same page. Now, there's going to be controversial stuff, and some of the stuff I will tell you, from my perspective, you may want to look at it extra because I'm not here to make policy. You make policy. I'm here to give you legal advice. I will definitely tell you, hey, the law says you can or cannot do something, but there's a big range in between that. Historically, you also need to know for the new members of the committee, you have the ability to require the county executive to give you a lot of information. You can't necessarily control what the county executive does. We have the ability for reports on things and information on things, anything that helps you in your legislative capacity, you have the ability to get them to give you. And so I wanted to have you all keep that in mind. And if anybody has any other questions for me on my process or how we're going about this, I wanted to, I'm here to answer them, and I'm always available for you guys to call me. I don't mind talking to you at home. I'm retired. I don't do anything except this part-time. I don't have a law practice or anything. So I wanted to let you know, I don't feel bad. You don't bother me. You leave a message, I will call you back in case I'm, out in the yard working in the summer or something. But that's basically what I wanted to inform everybody of.
Okay. Thank you very, very much. Phil is always easy to reach and very good at answering questions. So we have each of the chapters that the committee had previously reviewed on the list here. I'd like to, I'm hoping that everybody's had a chance to review them, take a look. If they've made, had any questions, they've written them down, but I'd like to go one section at a time, starting with Title I, Chapter 10. And
Could I say one
Yes.
more thing?
Yes.
I'm sorry, I meant to tell the committee this. My other process I wanted to do that I forgot to tell you, I told Sandy already. I will always give you guys the one with the strikeouts and the additions. When it goes to executive, after you guys approve that, I plan on giving them two, a strikeout and addition, a clean copy to vote on, and the resolution that adopts it.
That'll adopt it.
But that will not, unless you want me to give that to you guys, I will if you want me to, but what I will do is it's easier for me once I get what we approve here at this committee,
Mhm.
then I'll make the clean copy off of that to send to executive, and they can amend it too, and so can the board as a whole.
Mhm.
But that was my procedure, and when I say I'm sending the original to you, you're gonna be on the executive committee, I'll send it to you first, the clean copies, and again, with Chuck and Mike
Yeah,
Mahoney
you
and
can get it out.
and staff.
Mhm.
But I just wanted to let you know, I forgot to tell you that I intend to do that and it will be done.
Is that so that there isn't any mistakes between the strikeout one and the new
Right.
one? That's why you're
Because what
sending
I
them
will
both
do is
together?
whatever we approve here,
Mhm.
I will fix. If you modify anything, I will fix it on my computer and then I make the clean copy off of that one.
Yeah, because one thing I've noticed with Word, and this came up during the reorganization, when you send it to somebody, even if all the red lines and the strikeouts are in there, when they open it, just open it, it comes out as if it's totally been approved. You have to download it and then open it again in order to actually
And-
see
and-
the strikeout.
Right, in order to modify it, right.
Yeah, okay, all right. That part's fine. And that is the process, by the way. As soon as we let go of one of these, they will go to the executive committee for another review, and then it will go to the full board. And the idea is to get some of these approved while we continue to work on others. So, Member Butler, you had a question, and I'm gonna see if I can do this here. Well, there we go. Okay,
So I was just hoping that in ordinances, when we cite a statute, that we could give the page number.
Mm,
I don't understand.
no, just
So-
Member Butler, the statute could be any number of page numbers unless you're looking exactly at the one for the state of
When
Illinois.
there's an ordinance in ordinances, it just says as an explanation, the statute, and
Mhm.
it lists the whole 1,000 pages or whatever. Instead of listing the 1,000 pages, take it to the exact page in the document that explains whatever category it's in.
Okay, let me just clarify then. You're saying 55 ILCS 5/5-1004 isn't enough for you? Because it's in the section 1004
That's 5-5
on this
through
particular one that I.
1004.
Yeah,
So, well, honestly, even that description is not entirely accurate.
but if you put that in a search engine, it will bring you right to that very section.
Yeah, what I'm saying is like, because we have a different
Because page
form.
numbers could change if they make updates to the statute, because the statute is more than just the county government. It's all government. And so state government included. So if they add, pieces, parts here and there, the page number is going to change. It's going to be kind of irrelevant.
Different books have different page numbers. too.
Correct, that too. So I really
So also.
appreciate your request, but I'm
some-
not sure if it's realistic.
I was looking for all this stuff and I was trying to read statutes and such, and I noticed that this statute applied to all county, township. Can I at least finish the question before you try to answer it?
No, I'm not trying to answer. That's what I was going to tell you. I'm not sure that's relevant to what we're responsible for in this committee.
You can't know if it's
And
relevant
I
if you
would-
don't let me ask the question. And the question was directed towards the person who said if we had any questions. So I'm just asking for if there's some way we can clarify. When I looked this up for township styles of government, it was under this heading, but there was a different heading for executive forms of government within the same, statutes.
Mhm.
So I was just wondering if there's a way to clarify that for us so that we didn't look up statutes that applied to townships that when we're not in a township.
No, the Illinois Supreme Court said we still use the township
Mhm.
form of county board, except for where the county executive act specifically applies. So it may be the normal one that gets cited because it's still applicable. And that's based on Supreme Court cases.
So where we talk about the county executive, there would be a different statute listed. Is that correct?
Sometimes,
Okay.
sometimes. The,
All
right now.
well, that's what was confusing me
Yeah.
when I was looking.
We originally,
Mhm.
we just said, forget all forms of government. The state's attorney's office gave a legal opinion when the County Executive Act was passed. We only follow this one provision that says county executive form of government. I think it was Champaign County didn't agree with our interpretation. They took it up to the Supreme Court. Later, the legislature made a fix and changed it and said, all these executive forms of government except Champaign County shall do this. But the Supreme Court, prior to that, interpreted it and said, we still are a township form of county because we still have townships. However, the county executive, where applicable, overrules the general language of the township, but it doesn't vacate the general language of the township. And that's why if it's cited, it still applies.
Okay, so say that again.
The county executive form of government overrules. It's more powerful. It's like the US Supreme Court over the Illinois Supreme Court. But that doesn't mean Illinois Supreme Court opinions on other things aren't still law. It's only when they're modified by a higher thing. So the township form of county government still applies to us unless the county executive form specifically addresses that issue, which it probably specifically addresses like 99.9% of the stuff. And the main thing that came,
The only 1% would still apply to township?
that was the whole fight over, are we county board chairman or are we county board speakers?
Okay.
That's what that case was
So,
about.
so we list the statutes for the township style of government, even though only 1% of it is probably covered by that.
But that means if I list it, it covers what we're talking about there.
And you wouldn't list the other one where people would actually go to see what the real rules are.
No, the real rules, if they apply over it, I would list that one. I list the one that applies to it.
I'll talk to you about it. I don't want
All
to
right.
take up too much more of the
Thank
meeting,
you.
but that is.
And if you ever get a specific question,
Yeah.
finding a law, call me and I'll email it to you.
Okay, and this is why Phil has been generous to offer his time so that you can approach him with your individual questions, because it may not be a concern of everybody else on the committee. And if you get the clarification, then you may not need to ask the question.
And I'll, like I said, I'll look up
Yes.
your stuff. I'll email it to you. I'll tell you whatever that helps you.
All right, so I'm gonna dare to say we're gonna start with Title I. Chapter 10, General Provisions. I've reviewed this multiple times. I only had one question and I really don't even want to bring it up. So does anyone else have anything that they want to say about this before we recommend that it goes to the executive committee? Hold on just a second, dear.
I do.
We were good with it.
Okay, go ahead, Member Butler.
So one thing that I wanted to get clearly defined is the meaning or the application of advice and consent.
Is there
There's no
a
statute.
particular section here you're referencing?
Well, I'm just talking about wherever they use the term advice and consent.
Do they use that in chapter 10?
I'll see it.
Well, it's just a bland that covers everything,
Okay.
so I didn't know where to ask the question, so I figured I'd put it here.
Are you asking that we should have a definition of advice and consent?
Yes.
There is no set definition because courts have interpreted advice and consent as magic words, and on certain things it means one thing and on certain things it means another.
100%.
You're
That's
never-
why I would like a clear definition.
But
You're
not
never going to have
get
a
it.
clear definition
Why not?
because all power comes from the state in a state system of government. If the courts in the state give a definition, they are a state agency. If the county decides we don't want to follow their definition and make our own, it has no force and effect because the state supremacy still applies.
So the state put in the statute advice and consent.
Correct.
Okay, so classically, advice and consent is handled in two ways. either no one objects to what is motion being brought forward, and that is consent, or with advice, which is a vote. So I would like to know, is there a clarification that we could say when the executive wants to make her picks for different boards and they come before the board, does the board get to say yes or no?
Yes.
Yes.
So if
Advice
there
and
is a vote.
consent. Advice and consent always is involving consent. Consent means vote.
Okay, so I just wanted it to be clear that there is a vote
It always,
under advice and consent.
now there's a, if it may say with advice, there's not necessarily consent. There doesn't have to be a vote, but that means you could pass a resolution saying, we want you to take this policy. That would be advice. But if it says advice and consent, consent means you have to approve or disapprove an action. It doesn't give you the ability to choose first. You don't get to say, there's 5 candidates and I like candidate A. Executive wants to put candidate C first. You don't get C first, but you get the advice, consent on candidate that they give you. Right.
So that was a very good definition, and I appreciate you giving it.
But that's not in any statute or anything. By case interpretation.
So a lot of times advice and consent comes into question. So I just thought it'd be nice to have clarification in her rules, what it was.
Again, clarification comes from what the courts have interpreted to be.
I didn't turn it off.
Okay, so
Can you-
have to get-
Hit your button again.
Oh, I'm sorry.
I don't know that you did it, but it certainly died.
Madam
on-
Chair, may I make a comment?
Yes,
I
please,
think
Member
as-
Freeman.
I think as you see, as you read through that, when we've made it pretty clear that if it needs to come before the board, it says will come before the board, and other parts, it gives the abilities of the county executive under the Senate Bill 1015. So it's that we don't have a definition for it per se, Madam Chair, but we do have it throughout the documents.
Mhm.
It specifically says where it has to come, and I think that addresses.
It
my
does.
concern.
It absolutely does. And I appreciate Mr. Mock's definition of advice and consent. And these are the kinds of questions, again, that, you can either go to law school for, or you can give Phil a call and get the answers. Did we have anything else in here that somebody wanted to bring forward as a concern? Okay, so this one, do we need to take a vote? Oh, we don't have a state's attorney individually to send these to the,
I would do,
are you, you're our, well,
Right.
no, because normally,
no, I'm
you're the official state's attorney
for
for this
this
meeting.
purpose.
Okay, so do we need a vote to bring this one to executive committee?
I would recommend we do Title I as a whole because it's all just Chapter 10.
Mm-hmm. Okay, thank you, Member Newquist. Second by Member Freeman. Can we have a previous? Anybody?
I wasn't here.
Now, just, why don't you do this one
Oh,
first?
that's right. You missed the roll call. Please, Sandy, can you do a clean roll? Oh,
Logan,
Yes.
Bullock,
yes.
Butler, Newquist,
Yes.
Freeman,
Yes.
Trainier.
Yes.
Motion passes.
Motion passes. Okay. Now we are on to Title III. This is administration, and the majority of the changes, well, the changes have already been put in that were discussed at committee, but I know we have some folks that maybe are questioning some things. So this would be Title III, Chapter 30. Sorry, the first chapter, County Board.
The administration.
Correct.
All right.
And it's Chapter 30, County Board. All right. Member Bullock, I know this is all new to you. Did you have any questions? Turn your mic on. If you do.
Phil, Is it possible, as we go through sections, if there's big strikeouts, that you can say, these are struck because
Oh,
they've
sure.
been moved, or these are struck because no longer relevant, or anything like that?
Yep.
Yes.
Do that.
Just, and also, these are inserted because they are someplace else and now need to be in here, or,
Oh, I can do that real quick if you want.
Yeah.
that would be helpful.
Mhm.
If,
A
All right.
lot of this has to do with the county executive form of government
right,
that
Right.
changes,
And
starting on, I guess you'd call it page 4 or
Yeah.
5-4.
And when I give you the next set,
Mhm.
just for working purposes, not to be included in the clean copy, I will put page numbers in each chapter.
Okay.
But the clean copy, so you know, will not have
Any
those
page numbers.
because the whole book by American Publishing will have its own page numbers from beginning to end. But I'll start doing that to make it a little easier for us.
Okay.
So for right now, if we get into the end of 3 and the beginning of 4, all that language is struck because that was language from back when there was no county executive and the county board had to do the personnel filling. In fact, when I first started when I was hired in 1980, the county board set every individual salary of individual person in every elected official's office. They literally, when they passed the budget, there was code numbers for each position and a person got put into that position and made that money. That later got eliminated because there were statutes that said the elected officials control the internal operations of their office. But those are the type of administrative dual hat functions you guys used to have.
Okay.
But that's why that was a large area that was struck out. Now I'm going to keep going and see if I find any more.
And 30.02 added a bunch of language under number 3, starting with F, and that just really clarified the responsibilities of the committees.
Correct.
Mhm.
And I think there's one more big strikeout a little further down in, oh geez.
Well, we struck out some of the committees that we don't have anymore.
Right, right.
And again, what I did with these is our code of ordinances set up all these committees back. I think this one was done, the last changes were done when we did the first landfill. That's how long ago it was. And I looked, last 2 years ago, I looked at your committee structure and made it match. Then you haven't passed a new one. I made it match this time and that's what's in here.
Mhm.
I want to let all the board members know. Theoretically, every 2 years when you reorganize, you should also change your code of ordinances to match your organizational structure. But I put language in here that specifically says your organizational structure will outweigh or supersede the code of ordinances. So if in 2 years you want to go down to 2 committees, you could have 2 committees, even though your code of ordinances said all these ones that we currently have. So some citizen doesn't sue us and say, you're not doing your job right because you're not doing these committees.
And
I'm
we've-
hoping we do it right, but I just wanted to let you know I did put that catch-all language in there.
And we did add that the committees shall receive annual reports from the Will County Mental Health Board. That was kind of a big one.
Right?
And then we did some striking after that, and I think that's like on page 6 or whatever. And that was, again, dealing with the landfill committee, because it used to be 2 committees that managed the landfill. Now it's a separate committee altogether, so you'll see a big strikeout there. We no longer have an insurance and personnel committee. That's now done by the executive committee.
If you go to the second to the last page,
Yeah,
there's a policy consideration we need to discuss. On 3005,
settlement authority?
yes,
Mm-hmm.
this I struck out and changed. I want to let you know, your rules do not say this time. But I also want to point out to you, it's my legal opinion and the office's legal opinion from talking to them. Theoretically and technically, you guys shouldn't be doing approvals of settlements because that's an executive function. You do hold the purse strings, but you pass a tort immunity fund that's controlled by the executive that says, can here's $4 million to handle all your legal lawsuits, lawyers' fees, witness fees, court reporter fees, settlement money. And the executive's supposed to use their authority. However, I left in here, even though my personal belief is you shouldn't legally have to approve settlements over 100,000. I left it in here because the human resource people wanted you to have that authority. Because the human resource people basically, if there's something big that gets settled and there's pushback, they want to push the blame on you guys too, in my opinion. So I did have still in here settlement offers or offers are anything 100,000 or over, you guys have to approve it. And the reason this was all set out the way it was originally, again, is there was no executive and you had various structures approving it, third-party administrators we used to pay for and we gave them authority, but that's no longer the case. If there's a third-party administrator, the executive controls that. That's an executive function. So I did want to let you know that, and that's why that is in there. And, but I did leave the 100,000 in there, although, again, my legal opinion is if they settle a case, you can't take them to court and fight it because that's their legal ability. And just because you pass something, if it exceeds your statutory authority, you can't do it.
Mhm.
Now, there's an argument to make. If the executive signs it, they may be considered acquiescing to their usurpation of power, but that's until the courts determine it, we'll never know.
So that was kind of my question that I had thought about since you and I met was, did the county executive have any particular angst about our leaving this in here?
I didn't talk to them personally. I did talk to Regina, and she said she's fine with it that way.
Okay. And Member Freeman, you had a question?
Yeah, I know, I was looking at this and I know we've had a couple of times where as committees, we have wished for public comment not public, but committee member comment section. Would this be where we would add that? Because it's got.
That's usually in the order of business,
Well, it
the
also
agenda.
has it in here.
It's in here?
It's in here. It's in here.
Yeah, we did add the public comment.
You know what page you're on?
30.03, section A, and it would be somewhere between numbers 1 and 15. I would
So
assume it
that
would
my
be
other
closer to the
question,
end.
just to kind of go along with that, and I don't have all of this stuff memorized. I don't think anybody does.
I'm getting pretty
um,
close.
Would be the whole proclamation conversation.
Oh, we did put it in
Yeah,
there.
comments by
Okay.
county board members, we put it in there.
Yeah, it's there.
Okay.
Yeah,
Did I-
comments by county board members is definitely there. Honorary proclamations is still there, even though I don't think that's in our rules, but we decided that we would have them.
Are we done with this part then?
Yeah.
With unanimous vote.
One of those numbers has got to change.
Oh, okay, hold on just a second. Yeah, they said if it was unanimous at the
Well, then I'm good.
executive committee. All right,
Sorry.
hold on,
didn't see that.
Vice Chair Logan.
Phil,
Yeah,
$100,000,
yes.
what if it's $100,000 exactly?
If it's 100,000 exactly, the risk manager, human resource does it. It's 100,000 and one penny brings it to you guys.
Does that clarify
Can we
it?
change that then?
No, the language fine is up to 100,000.
If you want to change it to $99,999.99, you could. It don't matter. No, I mean, you can.
You want to
It
change it?
depends on how many you want to see.
It's up to you, then that's fine.
No, it depends on how many you want to see, but it's.
Yeah.
And here's another problem we have, you all need to know. When we get called to federal court and state, we never get state judgments against us this big or settlements this big. But when we go to federal court, the first thing the federal judge or magistrate says, send somebody that has settlement authority. And the first thing we have to do is say, we don't. And we can bring the head of HR with us. And if it's over a certain dollar amount, we have to say, by law, by our rules, we don't. And we can't violate the Open Meetings Act and bring a majority of a quorum of a county board up here to tell you this. We get in big fights with the judges because they don't understand that, because Their superior, obviously, being federal, they don't care about the state law.
That's one way to put it.
So usually up to $100,000, we can bring somebody with us that has authority. Either they give us the authority or outside counsel authority, or they'll bring, or we'll bring one of the HR people with us
Mhm.
and say up to 100,000, this person has authority. And after that, you got to go to the board, and that's just the law, and too bad.
Yep. Thank you.
Thank you.
Member Newquist.
I am probably not remembering this correctly, but if under the section that we're in now, the 3.03,
Yes.
C, parliamentary procedure,
Yes.
correct me if I'm wrong, but didn't we decide that we didn't need that in here because it's covered by our rules versus an ordinance, or am I imagining?
Which
that?
one are you
No, no,
talking
no. We're trying to make the ordinance
Match our.
Match
the
the rules.
rules. And I took it out of what your current rules say. But
Okay,
again, I have language in here. If you change your rules next time, that'll supersede it. Until we get around to realizing we should make the ordinance match.
so why would we need an ordinance to cover parliamentary procedure?
Because
since
part
it's
of it
in
is
the
so when a
rules?
citizen wants to know what's going on with government, they go to the county clerk's website and they can look at the code of ordinances and read it. The county clerk's website, unless they knew how to make their way through every resolution, they wouldn't find it.
Okay,
So it's sort of for the public to know.
okay, thanks. I was just,
I
Member,
kind of feel like if it's, I'm sorry, can I
no,
speak?
that's okay, Member Freeman.
I also I think it's important to have it here. I went to a session with the Forest Preserve, on what to include in your manuals. And the gentleman was talking about, there's this other form that's better than Robert's rules. But when I went up to him, he saw that I was from Will County and he's like, oh, no, Will County needs Robert's rules. Don't go away from Robert. You keep that. I was not even offended, but, to have it here means that we can't just take it out of our rules and try this other thing that somebody said was good. We have to do a great big change. And I think that, just hearing that guy say, no, you're Will County, keep it there is enough for me.
The more times we can repeat those decorum things, the better.
Right.
Member Butler.
Okay, since we're on parliamentary procedure, it's come to my attention that on, what is it? B, speak only when recognized by a county executive during the county board minutes, during county board meetings, or by the committee chair at committee meetings. So there was a long discussion, there was a vote, it was a unanimous vote to remove only from that statement. Because
Where are you at, Dan?
on parliamentary
Same
procedure,
section. With the
B.
Robert's Rule thing.
4B.
Yeah.
Number 4B, yes.
oh, okay.
so the debate was about 10 minutes. The vote was unanimous that it get removed. It was not removed. It was put in our ordinances, it was put in our rule book, and it was removed, it wasn't in the minutes. I had to go to the video to get it out of the video. It's 5:08 is when the vote starts, but the conversation probably started, 5 minutes prior to that. So I want that changed right away.
Okay, well, I haven't had a chance to review the minutes that you've reviewed. I can't believe I would have voted yes for that, but maybe after 5 hours and 8 minutes, I was exhausted and didn't really care.
Well,
How does this
regardless,
committee feel about the word only? And I'll
It's
go
not-
around the room.
let me just finish my statement because I'm not asking the committee's opinion on it. I'm stating that the board already ruled on it, voted on it, and the rules were recorded incorrectly.
But, okay, but what I will say is that this supersedes, unless I'm mistaken, our rules. And we would need to change our rule to make the rule match our
Well,
ordinance.
like every committee that is formed, it is just going to be a recommendation to
Mhm.
the board because the board overrules all committees.
Correct.
And it has been done. So I'm just saying that as it's read now, it is incorrect.
Well, does anybody have a copy of our rules?
They're incorrect.
I know, but you're saying they're incorrect, but they're the ones that was put in writing and
Is the
signed
word
and
only in
approved.
there?
If they're erroneous, that doesn't mean they're incorrect. That's what happened and that's what is approved.
Okay.
That's what your rules
So
say.
But no,
I'm
they're
going to ask
they're
each
incorrect
member
because-
of this committee to give an opinion on whether they want the word only or not. And then the next committee that looks at all this, the executive committee, if they decide to strike something or add something, then, the executive committee will then have the responsibility of bringing forward a rule change. Yes.
Madam Chairman, I'd request you have Member Butler make a motion to strike the word only from that, get a second and take a vote.
Okay, make your motion.
I make a motion to strike the word only from this statement as was voted on in the board meeting.
We have a second?
I'll second it.
Discussion?
Yes, please. Member Newquist, let me get your mic.
So I have a question. Phil, if we remove the word only, what does that mean? That anybody can speak at any time? Or,
It still then says speak when recognized, so you're technically not supposed to speak if you're not recognized. But it's a matter of your preference on how you want it to be worded.
but I mean, there's literally no difference. If we remove the word only, there's,
May I?
hold on, Dan, I'm not done yet.
Legally, there's not much difference, only has a stronger emphasis on it. But you're right, when it says speak when recognized, the inference is you're not supposed to speak when you're not recognized. But you can read it a different way too, and I'm not trying to be weird.
Mhm. I'm
You
asking.
can read it, speak as in speak to the public body versus speak to the person next to you possibly. Those all have magic words too. But again, it's your guys' decision, however you want to have it written.
What do our rules actually say right now?
They say only.
Okay. Thank you.
May I?
According to Dan.
Just-
According to Dan.
To eliminate a lot of this, normally during like a meeting like this, when someone brings up a motion, the first person that speaks is the person who brought up the motion because they could answer a lot of the questions.
Feel
So-
free, Dan.
You have to question why the county board in their bylaws and in their ordinances would come up with a rule that's already in place. So because the wording of the rule is slightly different than what's in Robert's rules, it makes you think that there's more emphasis on the word only. So while in a discussion, and as we said at the board meeting, when a discussion is happening, if someone thought that the rules wouldn't be followed properly and they needed to stop the conversation, they, in Robert's rules, have the right to call for a point of order. At that moment, they do not need to be recognized. And the chair must recognize or allow for that point of order. The chair's response would be, what is your point of order? And then you could state the rule. And then we could see if the meeting is proceeding in an illegal manner. Okay? So the idea is to protect the board, to have its power and to control the flow of the meeting so that things don't get passed. And once, like, if they wanted to say, have somebody call the question before somebody was able to speak and they were advancing illegally and nobody could call a rule or something, they could just do that. Or they could move to the next subject. Okay? There were times when we fought against when we were fighting to keep the old courthouse building, okay? And Vince had stood up and said, hey, I want to make a motion to let this guy from the Historical Preservation Society speak a little longer. And, he said, the executive said no. And she moved on. And I stood up and I said, point of order, and it became a little contentious. But then finally, what's your point of order? I believe that member Logan was requesting to suspend rules to allow this gentleman to have a little more time to present his case. Well, she said, well, he didn't say that. Well, because the rules were clarified, we had the point of order, there was a vote taken. On that vote, 18-3 voted to hear him out. So the whole board could have been wanting something to happen, but because the meeting was progressing and it wasn't happening in a manner that was adhering to the rules, that person's statement would have been left out. So this is an example of where point of order should be allowed. And so unless you don't know the rules, unless maybe they didn't know the rules, why would you put a rule that supposedly only mimics the rule that's already in place? if it's not to strengthen the language so that later we could be in a board meeting and someone have to say point of order and not be listened to. And the state's attorney could say, well, because it is in the bylaws that you can only speak if recognized and only the chair can recognize you, then you cannot speak. You put it in your bylaws. So either take the whole thing out and follow Robert's rules the way it was intended, or take out only, which could be determined or, interpreted the way the executive or whoever's representing the state's attorney wants to support. So that's why I objected to it, and that's what I argued, and that's why 20 people voted to take it out, because it only empowers the board to have the strength to set policy through proper debate. And that's a whole reason that Robert's Rules has been invented, to have productive and speedy meetings, but allow an orderly continuation of that meeting. And so this, I feel, infringes on the board members' powers to do that. It's
Are-
for
are you
both
finished?
sides. I am.
Okay, good. Next, Board Member Freeman.
So I'm hearing that we voted to take only out, but I don't have my notes in front of me
I don't either.
about that. Is there a way to find that anywhere?
508.
I'm sorry, I'm speaking. Is there a way to find out? Because I don't want to change something here
Mhm.
if it was changed. I mean, yes, we want to make it the same, but I don't want to make changes here without knowing for sure
What we
that the
did there.
changes were made there. So is it possible for the chief of staff to find that for us?
Yep, he'll get it.
Member Butler brought this up to my attention yesterday.
You're not.
You're not on,
Oh, sorry. There's multiples.
he hasn't hit his button
This
yet.
one's not on.
Yeah, it is.
Oh, I think you got a loose microphone.
Or you can use yours, Jackie.
Yeah, that's fine.
It's over, Jack. There you go.
Member Butler brought this up to my attention yesterday. I haven't had a chance yet to review the audio on it, but we will, and we'll bring it back to your attention, what the actual vote was on that.
So at this point, I would almost suggest that we hold off until we either have our notes or we have proof, because I'm refusing to change anything like that. Once I know that this section, I thought this section had already been voted on in the county board as well. But I could be incorrect on that. It's been a while. But I know our rules were voted on and they have been provided to us and they are at home and I have all my notes. So, that's up to you, Chair.
No, I wish I would have known about this last night because I have access to the video from the meeting, as most of us do from YouTube. And I would have gone right to the video to listen to the debate and the discussion. Member Bullock.
As a very experienced user of Robert Rules of Order, I agree with what you're saying, Dan, as far as the point of order should stop business, should be recognized, you should speak. I don't feel that the inclusion of only is meant to negate that from happening. From my short experience observing our board meetings in the past before I became a member, you guys talked over each other all the time. All the time, whether you were called on or not. And so the point of only, I feel, is to stress that you can't just stand up and talk over each other when somebody's talking because it's not your turn yet. That's my take on what the only is for. I fully support somebody saying a point of order, everything should stop. You should be called on, whether it says only or not.
Thank you. Member Freeman,
No,
are
I
you?
just- I'm
oh,
still on.
Member Butler, did you have anything else to add?
Yeah, so again, in Robert's Rules of Order, it clearly states that anyone who wants to speak has to be recognized by the chair. So why are we rewriting that rule with stronger language? That's my problem. And, with all due respect, there's been many times where, little words like that matter. And you can't go on with your argument because of something that was written. I forget, it was just something that recently about, ad hoc committees, talking about that, and, in Robert's rules, it's clearly states how it's supposed to be, but, Mary says, well, it was put in the rules that it has to be, dissolved by the executive committee. Well, yes and no, okay, but because the state's attorney agreed with that, it became very contentious. Ultimately, if we prevailed, and allowed that to continue, but I'm just saying, there shouldn't even be a system for that. Robert's Rules has already figured this out. You must, the chair can say, hey, you have not been recognized, sit down. That's already a rule. So why are we saying only? It's we've been told it's stronger language. So this works for both sides. This isn't just for one side. This is for both sides. This is to keep the strength of the board and our ability to debate and get topics discussed. So that's why I just, I'm very adamant on it. And for all, hour 5, minute 8 is the beginning of the vote. And you can listen, it's 2 minutes for the vote. It's 20-0. And if you want to listen prior to that, you can hear the whole argument.
Okay. Does anyone else have a question?
Okay.
Yes, Member Williams. Go ahead.
So,
Oops. Sorry.
okay.
Now,
Well, from what Member Butler is saying, we may not need it at all. I agree with him. If it's already in Roberts, we're following Roberts. We, in our rules, we put that we're following Roberts. We probably are being redundant.
yes, Mr. Mock.
I don't know if necessarily Member Butler's argument is against the word only. I think his argument is we should amend it, or this committee should amend it at the end, put a comma and say, except for a call for point of order.
I think that would solve the problem right away.
And parliamentary inquiry.
Yeah, again, if that's the 2 exceptions, then we
Well-
should put them in there.
I think that would solve the problem. Member,
But doesn't that, Phil, that's part of Robert's rules.
Except you got to read the
Yes.
first, read the very first, number 1. In the absence of a county board rule to the contrary, the parliamentary procedure of the board shall be governed by Robert's Rules of Order. There could be an argument that you're eliminating those 2 calls by having this specific procedure. Do you understand what I'm saying?
so Member Butler, would you like to change your motion to include those 2 exceptions?
So
Or do you want to move
If you-
forward? It's a
if-
yes or a no?
I just want to say in the minutes, it was removed the word only.
I know,
We
but
don't, we're not debating.
that may
Yeah, we
not solve
don't
your
know.
problem is all
Yeah.
I'm saying. Because somebody could still, and I would hope they wouldn't, I could be there advising the board and say, guess what? You can't make a call for a parliamentary procedure. You can't make that call because you weren't recognized yet. That call's irrelevant. That's why I'm saying maybe we should just say,
I don't follow the logic of that.
well, because the first thing says, in the absence of a county board rule to the contrary, parliamentary procedures shall be Robert's rule. If somebody wanted to misinterpret it, they could say, the change we added of speak only when recognized by the county executive prevents you from making those callouts. And I think what you want to do is preserve your right to make those callouts under Robert's rules. And I think the fact that we don't want board members talking over each other needs to be reinforced. You need the first half of that. But what I'm saying is, from a legal perspective, I think if you put at the end of that sentence B, except for these 2 parliamentary procedures that take precedence over everything else, and we list them and say, that's not overruled by this procedure.
Mhm.
That's what
And whether we have the word only or not
is irrelevant.
is irrelevant, because we've now clarified that these 2 parliamentary procedures supersede anything else.
Right,
And
they
I think
still
that
supersede.
answers his question. But Mr. Butler?
Well, I hesitate. I hear you, and I understand what you're saying. I hesitate because I haven't fully researched that possibility. And I know that the 2 examples I use are taking care of that. I'm trying to contemplate if it affects
Well-
anything else.
Well, we
but,
could put language to the, I'm sorry, I've spoke over you, I'm violating already. But we could put except when Robert's Rules of Order so provide. Because
then
that
that
makes
covers
Robert's
everything.
rules supersede this one again.
Yes.
Do you understand what I'm saying?
If you put that on that line,
30
that
minutes
one
late.
works.
Well, if you'd want to withdraw your motion,
I
withdraw
withdraw
the
my
second,
motion. Let me read that.
and then you can redo a new motion.
All right, what page is that on? So I gotta get this down right.
That was on
30.03C4B.
4B.
Okay, speak only when recognized by the, I move to amend parliamentary procedure 4B to say, speak only when recognized by the county executive during county board meetings or by committee chairs at committee meetings, except where allowed for in Robert's rules addition,
No, just say
whatever's
Robert's
adopted
rules.
by the
Yeah.
I
board.
don't think you want
Just
committee
say
meetings.
where parliamentary procedures prevail.
We're,
You want
okay,
to
Is that the right-
encompass all.
what she said.
Okay.
Can we have that read back?
I believe you said, except when Robert's Rules of Order so provides. I think that was-
Well, however he said it and she
That's what
said
he
it,
said, that's what
No,
he
it'll
said.
work.
I'm good with that wording, wherever it prevails.
Okay, except for where parliamentary procedures apply, it prevails. What do we want to say?
Where
Robert's
Robert's
rules.
Rules of Orders, parliamentary procedures prevails or whatever.
All right.
Okay. So we have a motion on the floor?
Did I get it read back? Is it still all jumbled?
Let Phil finish what he's
All right.
Okay.
I'm going to ask if this is the language because I'm trying to write it down too. I'm not trying to modify it. Except for where Robert Rules of Order parliamentary procedures, do you want to say prevail or apply?
Apply.
Apply, okay. I will amend, if you pass that, I will get it fixed before we
Yeah,
forward. it.
or so provide. Do you like? so-
Provides, fine too.
So
Yeah,
it's so
provide.
provide.
So
Just
provide. Okay.
Okay, now we have a motion, I believe. Thank you, member Newquist.
Just one more time.
One more time. Phil.
Except for where Robert's Rules of Order parliamentary procedures so provide. Is that language? Okay.
We have a motion and a second. Can I have a roll call?
Do we need a preview? Okay,
I want a roll call.
okay.
Logan,
Yes.
Bullock,
Yes.
Butler,
Yes.
Freeman,
Yes.
Newquist,
Yes.
Trinier.
Yes.
Motion passes.
Now, I want to go back to the word only, and I would recommend that we, in executive committee, make this match whatever was in the rules based on the report from the chief of staff on what was actually passed.
What I'd ask is we vote on it the way it is. 'Cause
now.
that's the way the written one was. Might be wrong.
Right,
And
but we'll let the
Then you would
executive
amend it at the next,
meeting. The
meeting.
executive committee will make the change.
Yeah.
To make it mirror. Mhm. Oh,
So, I'm sorry.
we don't know if it's working or not.
So the review I'm doing of the rules themselves, are those independent of what you're doing here, correct?
yeah, until it gets passed by the board, this is just all recommendations.
Okay,
So it can be
Well-
changed there too.
So the actual rule is how it's signed by the county executive, because that's what was produced and sent. And the,
How does a vote not be followed on a board meeting? How do 20 people of a legislative body who all vote unanimously for something not override a clerical mistake?
Excuse me, Member Butler, we can override a clerical mistake. The issue is that it's already been signed by the county executive. And so the state's attorney's office will have to advise us on legally how we move forward. How the mistake occurred is simple to explain. We had a major staff turnover during a reorganization meeting or shortly thereafter. So we'll find out what the minutes said in the actual recorded video of the meeting. And then we will proceed based on what the state's attorney's office tells us we need to do. Because right now it's already been signed and per your discussion, that word doesn't belong in there. So, yes.
and if I could address Mr. Butler's,
Mhm.
it happens all the time in court. A judge says something, a written order gets entered, the judge signs it, and it doesn't match his verbals. It's called a scrivener's error, but it's valid until it gets corrected. So that's what you're dealing with right now. It may not be right, but it's valid. That's two different things, but it has the ability to be corrected as a Scrivener's error.
There you go. So there's your answer. And had we known about it sooner, maybe we wouldn't have spent 25 minutes talking about a Scrivener's error. But, you know, it is what it is. And hopefully with Phil's offer to speak with you all individually and encourage you to reach out to him individually, we can move the proceedings of this committee along a little bit faster. So at this point, we have just two sections to bring forward to the executive.
You still have to vote
committee.
to bring this one forward
Yes.
as amended.
Yep.
Wait, we already had a motion, didn't we?
No, not to
Not
bring
to
the
bring
second one
forward.
forward.
Okay, but I still have two other topics.
In 30.
Well, it is.
3003. Okay, so real quick, I was talking about H, where it said all members of the county board should be in, or I'm adding that when, after the executive meeting and they approve the agenda, if there's any changes to the agenda, those changes should be sent out to separately to the county board, so we know they're there, so that when we go to the meeting, we're prepared. Because a lot of us check the agenda on Monday, because we're trying to get ready for Tuesday, and all of a sudden something's on there, because it was added at the last minute for Thursday's meeting, so.
If I could interrupt for just a second, Sandy, I seem to recall that we would get an email when something changed on the agenda, when an attachment was added. Am I mistaken?
I believe when they did attachments that were amended,
Uh-huh.
it was resent out
Mhm.
through the,
Yeah, we get an email.
through the minute track.
Correct.
And then it comes up as that there's the
Chief of Staff, Pelkey?
change.
I'm not familiar with how that process was working, but clearly, for the agenda shouldn't change. Once they've been posted. However, there are issues where we have added items, that this item was under consideration. Case in point, right now, we sent out already the executive committee agenda. We posted that executive committee agenda. We're still preparing the final county board agenda. So at the executive committee, they will sit down and they will vote on a draft of the county board agenda. We're still preparing them. By the end of the day, we'll actually have that attachment, for example, for the county board agenda. If there's a need to present the committee or notify the committee or notify all the county board members that we've added an attachment to the county board agendas, we certainly can do that.
Yeah, I believe we get those notices now,
I-
but.
One other thing,
Mhm.
I don't believe an motion to table and motion to postpone should be handled the same way unless clarified on how they're to be handled. They're two different items and they're confused a lot and there's a big significance in the way they're handled. So
Phil, do you want to
in
comment on
Robert's
that?
rules, they're not handled the same way.
I just took that out of what your new rules said. I have no idea how you want to do that. I'm serious.
Okay, well, it sounds like Mr. Butler has an idea.
Well, a motion to table is when some pressing matter must come before the board and there's not going to be enough time to handle the current subject. So they motion to table because the next subject is going to take a lot of time and is very urgent. And when that vote goes through, there is no discussion. So if anybody objected, they couldn't. So unless there is a underlying reason that is with a sense of urgency that requires it, then it should be postponed. And a motion to postpone, some people might object to a postponement and want to argue that. Okay? And they could under postpone, but when you table, you cannot argue it. It's just a vote. So I just think that they're two separate things. They should be handled as they are laid out in Robert's rules.
And I would add that this has been discussed at the county board before and similar argument made. And when we make a motion to postpone, we're supposed to give a date that we're postponing it to, whereas a motion to table doesn't necessarily require a date. Some of you were on the board when our current state senator Ventura was on the board. This was a big topic multiple times. And we did change, depending on the issue, we would ask the board member to make the motion to postpone to next month, to 60 days, whatever, but they always gave a date and we used postpone because that gave a date, whereas table does not. And
Right.
Mr.
With
Mock,
table, you have to sometime in the future move to take it off table. That's a good way to kill something if you
Right.
wanted to just kill it.
exactly. So we should probably clarify that in here. Member Berkowitz, you have your light on. You have a question?
I do, so.
Oh, yeah, sorry. I forgot I have to do something.
Thank you. So I have a question probably for Phil. I don't know if Chuck knows the answer to this question. So in here, in several places, we indicate that the public can address, the public can speak, but only on items that are relevant to something on the county board agenda.
Member Berkowitz, can I stop you right there? We'll come back to your question. I want to stick to the
Okay,
issue that has been brought up by the member of the committee.
sure.
Member Freeman.
Oh, I didn't have my light on.
Oh, sorry.
Sorry, I've just left it on.
I do.
It does make it easier for me. Go ahead, Member Newquist.
So I just want to clarify about tabling. I thought when you tabled something that it automatically was on the agenda at the next meeting. So it's not, you have to take it off the table?
You're supposed to move to take it off the table.
Oh, I don't know that we've ever done that.
No, you have. I've seen you do it in years past.
Okay.
Couple of times, but table and postpone have been used incorrectly on our county board.
Yes.
So I do agree that having this spelled out would be very helpful. Member Bullock.
Okay, so I appreciate the discussion is the difference between tabling or postponing. I think, however, that sentence means, because it says every motion shall be reduced to writing if requested by any member of the board. It also means a motion to table or a motion to postpone will be handled the same way, will be reduced to writing.
Mm.
It doesn't mean that
Okay,
they mean the same thing. I
okay.
think it's just saying that the writing is the piece
Thank you,
that will
Member
be handled the
Bullock.
same way.
Okay, so the motion must be in writing.
Correct.
No,
They
if
will,
requested.
it will be reduced to writing, just
requested.
as
If requested.
every
If
motion.
requested.
Okay, but because that question was coming up on how they were handling it, I thought that was the same
Yeah.
thing.
No, it speaks to the writing.
Is that,
If
is that
requested.
work?
That,
Yeah, you have to
Is that
read the
accurate?
whole section
Yeah.
together. You can't just take out
right, they
one
would have used
portion.
a separate section other than I if they were just dealing with those type of motions. Robert's rules would control those because it's not specific.
Okay.
And do we have that anywhere in here? I don't recall it being in here, is how you handle a motion to table or a motion to postpone.
That would look to Robert's rules.
Okay, then I'm going to look it up and
Yeah.
make a copy for everybody and put it on their desks so that people understand what that means and how what the difference between the two are and how they should be handled. Okay, that answers Mr. Butler's first question. What's your next question?
No,
Mr.
that was my
Butler?
second question. My first question was answered too.
Okay,
It
wonderful.
wasn't as bad as you thought. It went like so fast. It was like.
Only another 10 minutes. You're right.
I'm sorry.
Oh, okay, Member Bullock, go ahead.
Okay, so I know there was this conversation about agendas and everything. Okay, and when they come out and all that stuff. And I may have been looking at something else, but we crossed out 5 days because that's not
How
in
it
our rules
works.
anymore. So we don't have a set time we should be able to see an agenda that is,
Yes, there is a set time by state statute, and it's 48 hours before the beginning of the meeting. Now, we generally tend to exceed that, meaning more than 48 hours, but 48 hours is the law.
says that's what's in the Open Meetings Act, which is why we reference it, 48 hours now.
Mhm.
That does not give me a lot of prep time.
No, that's why it's important to kind of know what's going on, but yeah, difficult. Okay, that's it for this section. Member Berkowitz wanted to bring up an issue that I don't even know if it's covered in this section. Can you please hit your button?
So you kind of jumped over the section that I'm talking.
Can you please put your mic on?
Certainly, sorry.
All right.
Okay.
Was it in
Um,
chapter 30?
So it's going back to page 11, which is let's see, what chapter is that? Because you're on four,
We don't have page numbers. Please give us the section number in chapter 30.
okay.
Is it one of these?
Let's see, it's,
This? I think she's at 300315 possibly.
yeah, see, I don't have a printout, which you're looking at. I'm looking at my iPad.
It'll have a section number.
A15, sorry. Because there is no B.
Thank you, Phil. So my question is we state in here, let me go to,
Public comment relevant to matters under the jurisdiction of the county.
okay, so public comment for agenda items only, we indicate, we specify that, and then public comment relevant to matters under the jurisdiction of the county. Now, I understand, the public comment regarding matters under the jurisdiction of the county, but Phil, do we have the ability to prevent public comment from coming and just sharing public comment? Do we have the ability to restrict them to only what's on the agenda?
No, you've already done that. Under number 10, you have public comment on agenda items. I don't like this zoning case. I think you're making my taxes too high. Part number 15 is for public comment relevant to matters under the jurisdiction of the county, such as, I think all our road speeds, even though it's not on the agenda, I think our road speed should be lowered. Or I think the county should do this, or I think the county should buy this land. What we don't want to allow is we don't want somebody to come in there and talk to you on an issue that's not county related, such as, I really think that Middle East crisis is something you should do something about.
And
That's-
that is, the-
Okay, so
That's what it's about.
let me restate my question. So it says, number 10, public comment for agenda items only. So my question is we're indicating public comment is only for agenda items only.
On that part of on that part of your agenda or conduct of business.
Member Berkowitz, if I could try to help you with this, you want to let the people speak about the issues that we're just about to vote on so that we get to hear what they have to say before we take our vote. That's the first public comment.
Okay,
The second public comment is for anything under the jurisdiction of the county, maybe not even on the agenda today, maybe never on the agenda, but something the county has some say-so over. We don't have any say-so over who lives in Gaza or who rebuilds it. So if somebody tried to make public comment about that, we would rule them out of order, or presumably the county executive, the chair, would rule that out of order. You were not on the board when we used to have a visitor that would come and speak rather disparagingly about either county board members or the county executive, and sometimes talk about things totally unrelated to government. She was frequently escorted out of the building, but we had to allow her to speak at the point in the agenda that allows for you to speak on things not on the agenda. Did that explain it? I think. Yeah, at the end, after we've already voted on everything that's on the agenda.
okay, so we have the ability to indicate that the public cannot come into the county and speak about anything unless it's under the jurisdiction of the county. We
In
have
your-
that ability?
In your meeting, you have that ability. If they want to stand on the courthouse steps and say anything they want, that's a public square and they can talk. Your meeting is not a public square.
And who determines if it's under the jurisdiction of the county? I'm just saying, because
The chair.
from my perspective, we are a government entity. So if somebody comes in and they have a concern with national politics, we have to work with national politics and
Mhm.
in certain ways. So is that not under the jurisdiction of the county?
You're-
I think,
It's the prerogative of
So
the
it's-
chair.
okay, thank you.
and-
That's what I wanted to bring up.
Your jurisdiction of the county is set in the county code of ordinances. I mean, the state statute on counties. That gives you your jurisdiction. You have no authority unless the state gives it to you.
Mhm.
State
Right.
doesn't give you authority on what to do in Gaza.
Mhm.
You have no jurisdiction over that. They can't speak on that. Now, you can always If they phrase it the right way and say, boy, I'd like the county to pass a resolution recommending this, you got authority to recommend stuff. But if they're just up there complaining, gosh darn it, I just, I hate how this is going on. They can't talk about that. You talk about
No, I
that
know,
in public
but
square.
let's not talk about international. Let's
Well,
talk
even-
about,
It could be
Country
anything.
politics.
No, no,
Same
it could
thing,
be
country
anything.
politics.
it's under their prerogative.
If they don't have the right to tell the county about anything the governor is trying to do, anything the state legislature is trying to do. It's jurisdiction of the county, and the state government tells us what we can talk about, basically.
Well, I think that's kind of a broad
Yeah.
definition, so.
Take it up with
It
your
is what it
legislators.
is.
They could certainly change the statute. We can't.
Well,
All
we
right, so
can
we
be
made
more
it through a whopping 2 sections. I would like to get a motion to pass the second one, but I think Member Newquist has a question. And let me turn that back on. There you go.
Super quick, that section 15, public comment relevant to matters under the jurisdiction of the county, is that our language or is that state statute?
No, that's your language that you've adopted in your most recent rules.
Okay, thank you. I was just curious.
Yeah, y'all should have been here when we had that lovely lady come and speak, and I can't remember her name. Estella? No.
No.
Yeah,
don't
it was
remember
fun.
either,
All
but
right, can we get a motion for the second section, please? Did we pass it? Okay, we're in discussion.
No, that's.
Yeah,
really-
Sandy, do we have a motion on the second section?
I believe that Sherry did make a motion.
Did we get a
but I
second?
Don't think I have a second.
Okay, Member Freeman is going to second
I
it.
did- I'm sorry, I didn't.
And then can I have a previous, please?
Second.
All those in favor? All right, those opposed, same sign. The motion passes. Member Berkowitz, you have something to add?
I didn't get it out fast enough.
Oh,
Member Butler voted negative on the previous.
oh, do you want to be a yes on this one?
On-
Okay.
On the previous one, he was,
Did you have something else, member?
I didn't get it out fast.
Okay,
enough.
but you got to push your button.
oh, that. was-
I'm really trying here. This is not an easy job. I need an assistant.
I don't know if anyone said this, and I didn't get this out fast enough, but on page 13, number 3, line 6, there's a typo, so just correct. make the
Okay.
cor-
If it's just a typo, I'm sure you can let
Yeah,
Phil
let me
know and it'll be
wait,
fine.
where it is.
Justin, Jim.
Okay.
That's fine.
All right, we are 20 minutes past our allotted time. I will tell you that in the future, I'd like to schedule
No,
2-hour
right.
slots for this meeting because I would like to really get some things accomplished and move along and try to finish this during this century.
Number 13.
That's the other option is that we potentially meet more often. Do we have any public comment? Anybody from the
Second.
public? Any public comment? Okay. My announcement from the chair is we're going to have longer meetings or multiple meetings a month, but I think I'd rather do longer meetings. That way you don't have the travel time. So unless somebody objects, that's kind of where we're going to go. We don't have a need for executive session. I'll take a motion to adjourn.
Motion.
All those in favor?